Hi, this is Alan Gassman. Welcome to Tuesday, March 17, 2020. I'm here with Brandon Ketron, and we're going to talk about something very serious and something very meaningful as far as what we can do for our clients, our families, and our friends. We call this planning in view of the coronavirus. I'm actually presenting this from Santiago, Chile, where Marcia and I have been on vacation for a couple of weeks. Brandon's in the office holding down the fort with our other lawyers, and I thank them and our staff for that. This is a very challenging situation and a very big opportunity for estate planning lawyers and advisors. There are a lot of things going on, a lot of moving parts, and a lot of things, quite frankly, that many advisors gloss over or don't recognize. At this point in time, clients need more than just legal services. A lot of clients, especially business owners, are in grave peril. We don't know how long the economic slowdown is going to be. We don't know what all the implications are going to be. These clients need someone to talk to. They need someone who has some experience in this area, and quite often they need to make some moves and they don't even realize it yet. So we're going to be talking about that during this webinar. Secondly, there's a lot of extra panic that happens in situations like this. I've been through the AIDS epidemic situation. Almost everyone on this call went through the 9/11 situation. We've been through the 2007, 2008 Great Recession. We know that you don't panic, but you also don't ignore these situations, and you look for ways to make lemons into lemonade. Taking you to page 3, and again, there's many considerations here. If you are in a workplace or you are making decisions concerning a workplace, you have to take this virus seriously. Not only from a potential legal liability standpoint, not only from the standpoint of having the virus go through your office may cause loss of productivity and great expense, but also from the humanitarian standpoint, that we have an ethical duty to our employees, to our team members, to do the right thing. So deciding what the right thing is and paying the extra money for extra cleaning services, for gloves if they're available, for anyone who handles physical items that have been touched by somebody else, having a number of employees begin to work from home or from a different office that is less crowded, not letting people who are coughing or sneezing be in the vicinity of people who are not coughing or sneezing. Our Lineberg letter goes into great detail on this, and that is one of the materials that you're being provided with today. Make your decisions, do the best you can, and go on with it. Now, page 4, try to be in the very best physical health that you can be in. Try to encourage your loved ones and even your employees to be in the best physical health we can be in. The people dying from this virus, as I understand it, are not dying just because they have this virus. They are weaker in health, they have other issues. They were not on top of these other issues necessarily. So exercise, eating right, drinking less alcohol, making sure that medicines are being taken so that you have plenty of resistance, getting plenty of sleep, having reasonable amount of leisure time. That's all going to be very important, and the exercise will help with the anxiety situations. You are in a legal office or an accounting office, and people touch each other's computers, they touch each other's phones. I mark up documents and hand them to a paralegal. She touches them. You've got to think about the physical items, who's touching them, who has gloves, how you are going to avoid doing that. I'm even wondering whether I should be microwaving documents. I can mark up a document, put it in the microwave, have someone with gloves hand it from the microwave to my secretary, put a cup of tea in the microwave at the same time. Think of ways that you can come up with to have less physical contact. I'm going to be letting my clients know that I've been in Santiago, Chile, that I have been on an international flight to Miami, that I've been through the Miami airport to the Tampa airport, that I feel fine. But if they would prefer to have a video call with me instead of an in-person visit, that is, absolutely their choice. We all want to act responsibly here. One thing I'm going to mention, and it sounds silly, but if you're going to get this virus, it's probably best to get it immediately, because right now there's plenty of hospital beds and plenty of ventilators, plenty of people to take care of you, whereas later on, that may not be the case. So just thinking about that. Now, for a lot of clients, you've talked to them, you've told them they should get more life insurance. They've been reluctant or negligent or just haven't gotten around to it. We don't know if the life insurance industry is going to change. It may change for the worse. They may stop issuing new policies. I don't know. So it's a good idea for clients to use this Carbonis concern as a motivator to go ahead and sign up for their physicals to get their life insurance, their disability insurance, their business interruption insurance all underway if it's not underway already. Number 7, quarantine planning. Who would have thought a week ago that it would be hard to find toilet paper, it would be hard to find disinfectant, it would even be hard to find something to eat. So think about, what if I'm quarantined? What can I do now that's easy that will be very difficult if I'm quarantined? What devices and supplies do I need? Should I move my prescriptions from every 30 days to every 90 days so I have plenty at home? Do I have a rental property that I might want to kick the tenant out of if needed? Who's going to take care of my pets, et cetera, et cetera? Just something to think about. And for your elderly clients, are you going to call them, ask them how they're doing, and give them the nudge to go out less, spend more time in their apartment, get food service brought in? This storm of possible infection will hopefully be over soon, but before it is, it's the elderly clients that are going to have the terrible issues. And back to health. Are you taking vitamin C? Are you taking zinc? Are you tracking your exercise? That book you always wanted to read, do you have a copy in case you have the chance to read it now if you're out for 2 weeks? Brandon, tell us about this coronavirus legislation.
Yeah, so there's legislation that has passed the House. It's in the Senate currently as we're recording this webinar. Donald Trump has tweeted his support for it. But basically what it provides is if you have 500 employers or less, you are now going to be required to have paid family leave and paid sick leave for issues related to the coronavirus. So if you have an employee that's sick from the coronavirus, you're going to be required to provide them with paid sick leave for 14 days. If they have a family member who's sick with coronavirus and they have an obligation to support and care for that family member, if it's a parent or a child, you have to give them paid family leave related to that illness. Now, what the bill says is that we're going to provide the employers with a payroll tax credit up to a certain dollar amount and for a certain number of days to basically reimburse them for that excess cost that they're now going to have to provide these benefits. They did leave open the ability for the Department of Labor to pass some regulations to exempt employers that have less than 50 employees. So as of right now, it's looking like this is going to apply to anyone with between 50 and 500 employees. We'll stay stay updated on this, provide you with updates as they come available. We'll see if the Senate tweaks this at all and what bill we end up after it's signed by President Trump. So we'll likely do a webinar on this in the future, but just wanted to point it out now.
Brandon, usually when a law like this passes, they sneak in some other things, take us by surprise, or handle other areas of the Internal Revenue Code. I didn't notice anything like that. Did you?
It seems to be pretty straightforward, at least for now. We'll see if any, earmarks get tied in with the Senate as it goes through that process.
Right. Okay, very good. So now on page 10, I want to mention something that we see time and time again, and that is we have a client who's very sick in the hospital, and someone needs to lobby for her care. In other words, she's kind of getting ignored, or the doctor's gone for the weekend, the nurses aren't really giving her great attention, and the only one with the healthcare power of attorney is her husband, and he's not in great shape. He's at home, he's trying to sleep, and her son's there at the hospital, but the nurse can't talk to the son. The son is not the healthcare surrogate. So I recommend that clients have multiple co-active surrogates, that anyone has the power to act without joint or consent of the other. You can put in a provision indicating who you prefer to make decisions if there's a deadlock or a disagreement. But we certainly want to have healthcare powers of attorney up to date. Under the relatively new Florida statute, the agent under your healthcare power of attorney can also take care of your children. And clients should be asked, who do you want to take care of your children if you can't take care of them, or in the event of your death, who do you want to be the guardian? So just keep that in mind. And we have more. We also mentioned do not resuscitate orders on page 11. A do not resuscitate order, also known as a DNR, has to be signed by a doctor in Florida. It's a yellow sheet of paper. It says that the doctor has discussed the situation with the patient and that the medical personnel do not need to give CPM or make other heroic efforts to save that patient's life if the patient stops breathing or if their heart stops, etc. For elderly people with a short life expectancy, it is excruciating to have their ribs broken to give CPR, and it may be time to discuss the DNR with the doctor, get the yellow page, put it on the refrigerator, but it's different than a living will, it's different than a healthcare power of attorney. Speaking of your parents, many clients have getting their parents' estate plan on the agenda, but they haven't wanted to talk to the parent about it, or the parent has been non-responsive, or the parent's attorneys have been non-responsive. It is time to try again. Elderly people eventually get cooperative, maybe when they're scared about their health. Oftentimes, we prepare an irrevocable trust. We make the client the trustee. We ask their parents to make the trust the beneficiary of their will or trust. That way, we handle the drafting. We know it's done right. The parents don't have to worry so much about it. We have articles on what we call the irrevocable inheritance trust. You might want to think about it. Brandon, do you want to cover employee-employee relationships and the nudge towards independent contractor status for someone who starts to work at home?
Yeah, so now is a perfect time to just reconsider whether an employee or an independent contractor should be classified as one or the other. So now that you have a lot of people working from home, you're not providing with additional office space. Maybe those employees that don't have a whole lot of responsibilities or are maybe doing like straight manual dictation, you could outsource those to become independent contractors. Not only does that provide you with a nice result for not having to pay employment taxes, but it might allow them to qualify for the Section 199A deduction as well. So this really could be a win-win situation if you can convert some of those employees into independent contractors. In addition, you won't have to provide those employees with benefits any longer. So there could be some substantial savings there for you. But one thing you might have to watch out for is if you incorrectly classify these employees as independent contractors, it can mess up your pension plan. You could be liable for employment taxes. You could be liable to them for the loss of benefits. And there's a form that they can fill out on the IRS website to basically report you to the IRS if they think they're misclassified. So that's, you really have to pay attention here. Maybe consult with, an employment law expert as to whether or not you could reclassify some of these employees. As far as 199A goes, remember under the final regulations, if you are a former employee and now become an independent contractor, there's a presumption that you're still an employee and will not qualify for the deduction. That presumption lasts for 3 years. Now, there's ways to rebut that presumption, but if you are taking this position, you need to make sure you document that, okay, now I am no longer an employee. I have set up a corporation or an LLC to do my business. I have a contract with my independent contractor. I have a partnership operating shareholder agreement, all set in place as ways to rebut that presumption. And here it's directly from the statute. You can provide records such as contracts, partnership agreements that provide sufficient evidence to corroborate the individual status as a non-employee. That's how you rebut the presumption. And there's a couple of examples here that we have in the Section 199 regulations that give us some examples. And that Form SS8 that I mentioned is what the employee or independent contractor can fill out to helpfully recharacterize their classification. And here's what the factors are. There was traditionally always 3 factors: behavior control, financial control, or the relationship of the parties. There was a recent court case that came out that expanded these factors into really 20 separate factors. These 20 factors are listed here, and we've kind of put them in the category of what those traditional common law factors have related to. So we have behavior control, financial control, and again, relationship of the parties. So this is here for your information. If you're considering that, this is all for your benefit.
Brandon, what about the employment taxes? I know it's better for me to be an independent contractor because I'll save a 20%. I know it's better to be an independent contractor to have a 20% income tax deduction, but is there a way that I can avoid paying so much employment taxes?
Yeah, thanks, Alan. As you know, you set up these independent contractor relationships, and like you said, now you're maybe liable for self-employment taxes. So let's just go through a little background on who's subject to self-employment taxes, who isn't, and then you also have the net invested income tax out there as well. So traditional S corporation, the profits that aren't considered to be compensation to the shareholder, those are not subject to employment taxes as long as you pay a reasonable salary to anybody providing services in the entity. If you have a partnership that's owned by the S corporation, again, that blocks the employment taxes as well. If you're just a regular Schedule C sole proprietor, maybe a disregarded LLC, that's likely going to be subject to the self-employment taxes. You can get around the net investment income tax if you're active. Now, if you're a passive limited partner, those are going to be subject to the net investment income tax, but not subject to self-employment taxes. And again, it's the inverse if you are an active owner. You're not going to be subject to net investment income tax, but you are going to be subject to the self-employment tax. So what are ways where we're not subject to either one? Because traditionally, these kind of work with each other. Either you're subject to the net investment income tax or you're subject to self-employment tax, rarely both, and rarely neither one. But there are 2 ways that we can do this, and the first one is to have the ownership of the entity set up to be owned by the non-active spouse. So here, for example, we have ABC Partnership. Spouse 1 is the active individual that performs most of the services. You'll obviously pay that spouse a reasonable compensation subject to employment taxes, but the distributive share of the partnership earnings would not be subject to self-employment taxes because spouse 2 is the actual owner and spouse 2 is inactive. And the nice thing about this as well is you can combine spouse 1 and spouse 2 for net investment income tax purposes, so spouse 2 is deemed active for that, so they're not subject to either the self-employment taxes or the net investment income tax. The second way we can do this is through multiple entities. If you have several different entities altogether, you spend less than 500 hours on each individual entity, you're going to avoid the net investment income tax. But you can aggregate those, or sorry, you can aggregate those for net investment income tax purposes to exceed the 500 hours. But for self-employment taxes, if you spend less than 500 hours on each activity individually, you don't aggregate together. You just look at each subsidiary or partnership separately. Less than 500 hours avoids the self-employment taxes. So 2 ways here, a couple planning ideas that we wanted to throw in as part of this webinar.
All right. Now, probably the most important discussion point for business and investment-oriented clients is whether the world is going to come crashing in on them and what to do in advance. And let's remember, it wasn't raining when Noah built the ark, but for many of these clients, it is already raining. You have situations where you have clients with restaurants, and you know they've got enough cash for 3 months, and they're going to keep more staff than they need, and they're going to be out of money in 3 months, but they're confident that things are going to come back within 3 months. Well, guess what? We don't have any idea whether this thing is a 3-month problem or a 3-year problem. So somebody really needs to sit down with them. They are feeling and looking like a deer in the headlights. How much money do you have? How much are you losing a month? How long will that last you? How much have you borrowed? Will the lender work with you? Okay, you've laid off 20% of your employees and you put the rest on 30 hours a week. That buys you 3 months. In order to get a year, what do you have to do? You may have to close the restaurant down and do only takeout or do only dinner or find ways to make this thing last longer. What we found in 2008 with clients in many businesses was that they were not paying attention to the burn rate. They did not ratchet down their standard of living quick enough. They did not know how to explain to the employees that they were going to have to pay them less, but that they would get paid eventually if and when things got better. So clients all thought that their banker was their friend and they shouldn't have to worry. But then the banker came in and explained that the FDIC was in their office demanding that they call in this loan, demanding that they get their collateral, demanding that they get personal guarantees from the client's spouse. These things are already happening this week in your community. As you are well aware, many clients, when they did better, they expanded more, they used debt. And now it's not only the restaurant, it's not only the hotel. What about the hairdresser who does hair for people who work at the restaurant? What about the supplier to the restaurant? What about the company that sells equipment to restaurants? What about the companies that sell insurance to the companies who sell equipment to restaurants? This is all going to come buckling down on thinly capitalized clients. And in Florida, there's things that you can do to shore up their situation. Because is it better to spend all your money in 3 to 6 months letting your restaurant go down slowly, or to reserve enough money so that you could restart the restaurant after a bankruptcy? So maybe the client should not be putting money into the company right now. Maybe they should be keeping the money where it's already creditor protected, or possibly paying down a mortgage on the homestead so they can restart that restaurant and they don't have as much cash available when they come to negotiate with the bank. Don't try to do this without guidance from a good bankruptcy lawyer. Don't communicate anything in writing without guidance from a bankruptcy lawyer as to what will be discoverable and what will not be discoverable if the client ends up in bankruptcy. Don't take these clients and refer them to lawyers who put all the assets offshore and promise great results. This is not the time for that. But it is the time to sit down with the client, to see what their negative cash flow is, to see what they need to change, to update their estate plans, to shore up their creditor protection planning, to make moves where appropriate. And remember the preferential transfer rules. Under the preferential transfer rules, if my company is insolvent, I have a fiduciary duty to creditors. I can pay contemporaneous compensation in reasonable amounts to myself and others for services and materials actually provided to my company. But I can't pay old debts without having to worry about preferential transfer issues. I can't even pay the rent. If my mother guaranteed the lease and I pay the rent as it becomes due, and I file bankruptcy within a year, then under the preferential transfer rules, she may have been considered to have received the rent amount and have to cough it back up. So renegotiating with landlords and looking realistically at the situation is vitally important. For many clients, you will want to put an employment agreement in place. If you're going to use a CPA to help you with this process, you'll probably need to hire a CPA other than the CPA for the lawyer and enter into a confidentiality agreement where they're working for your law firm, because there's no CPA client privilege in bankruptcy. Brandon, what about planning for estate taxable clients with short life expectancies? Let's face it, some clients are going to be calling and saying, oh my gosh, my wealthy grandpa has the coronavirus. He certainly has better than a 50% chance of living. But the concern is that he's probably got a 30% chance of dying in the next 4 weeks. And he's got a $20 million estate. What can we do?
One potential planning idea is a self-canceling installment note. And the way the self-canceling installment note works is it's a traditional promissory note owed from either a trust or a child back to the seller of the business. And it says that in the event that the holder of the note were to die, that the note is automatically canceled and nothing further is owed. So if you have someone, maybe a 9-year note, they die in year 4, all the payments from year 4 and beyond are canceled from that point on. Now, the IRS has looked at these in the past. There's the Estate of Davison v. Commissioner case. It eventually settled out. But the IRS here argued that the self-canceling installment note was, little aggressive in this circumstance. They set this up. The grantor died shortly after the transaction. The IRS challenged it and said that they actually made a gift to the trust because the note did not reflect the actual economics of the transaction. Maybe there should have been a higher interest rate. There should have been a principal reduction, something to take into account that the maker of the note had a very short life expectancy, and it was known at that time. Now, if we set this up when there's at least a 50% chance of living, the IRS likely would not challenge that, but there's still some risk there as well. But again, there's ways we can avoid that risk by using the SCRAT, which Alan can explain now.
We came up with this arrangement called the SCRAT, where you set up an LLC. The LLC is owned by the individual. The LLC owns the self-canceling installment note to the individual. And in this example, if the LLC has $2 million of assets, the skin is $1.5 million owed to the client, we would take the position that LLC is worth $500,000. We put it in a GRAT. The GRAT pays the client $110,000 a year for 5 years. And if the client dies, the GRAT is only worth about $500,000. $1 million is out of the client's estate. But let's say the IRS comes in and says we've made a large gift because the skin is really not worth $1.5 million. The skin's only worth $500,000 because the client had the coronavirus. Did we make $1 million gift? The answer is no, because we used the GRAT. Instead of $1 million gift, we simply are owed larger payments from the GRAT. Instead of $110,000 a year for 5 years, maybe it's $210,000 a year for 5 years, but the IRS is not going to collect gift tax. So this client who had the coronavirus, who was concerned about estate tax, she gets better from the virus. She gets audited by the IRS. We know she's not going to owe gift tax. That's the SCRAT, and we have further information on the SCRAT. If you'd like to see a webinar on the SCRAT, just let us know. We've used it on several occasions to avoid significant estate tax. Now, page 38, interest rates are probably as low as we're going to see if they don't go negative. So this is a great time to make an installment sale to a defective grantor trust, as we call it, or to update and renew loan agreements with loved ones who are paying below interest rates. You can use the applicable federal rate, which, as you know, is very low. If it's for a sale of assets, you can use the lower of the rate this month and the previous 2 months. It's possible that if you're reducing the interest rate on an existing note, that it might be considered to be a gift, but it might not be considered to be a gift. We have an article on that we'll be glad to share with you. But when you run the numbers, even if it's considered to be a gift, the client usually comes out ahead. And we have the configuration here that we most commonly like to use. Brandon, you want to run through how this works?
Okay, so as Alan mentioned here, this is our typical setup for the installment sale to a grantor trust. We can do this with multiple promissory notes or just one, but we set this up. At first we do is we put everything into one LLC or one family limited partnership, and we get a valuation done on the value of that entity. Then we decide, okay, how much can we sell? How much does the client need to retain? We run some numbers and we make sure we show the clients the projections so they can make an informed decision. So they gift roughly around 10% of the value of the expected promissory note to the trust to seed the trust, because we want to have that trust to have some capital prior to enter this transaction, just to make it a little more realistic and practical. You wouldn't loan anyone any money if they didn't have any assets. So we want to make sure the trust has assets beforehand. 10% is usually the rule of thumb here. So we seed the gift, we can report that on the gift tax return, but then we enter into a sell agreement for the majority of the LLP or the LLC. So if it's 50%, we determine what the 50% value is. We take a discount, and then there's a promissory note owed by the trust back to the grantor of the trust. That's going to be disregarded for income tax purposes, so there'll be no tax event. But what that does is it really freezes the value of that percentage that you gifted or sold to the trust at today's value, and then at the value of the promissory note. So the note will have a rate of interest that's prescribed by the Treasury. It's the 75/20 rate. Right now, that's as low as it's ever going to be. I think it's around 1.38% as of right now, but that's definitely going to drop since they just adjusted the interest rate. So it's going to be probably less than 1%. So whatever the assets grow above that interest rate is shifted outside of the estate and is estate tax free. So this is really a traditional way to just freeze the value of your estate and gift it to the next generation without having to pay estate taxes. We ran some numbers here that we, as we said, we always show clients. This is assuming that they sold 50% to the new trust. The company's valued at $22.5 million. Half of that's going to be around $11 million. We take a discount on that, so the value of the discounted LLC interest is going to be $7.5 million. That's going to be the value of the note. We ran this out using a 20-year note, interest only. So in this scenario, the interest rate was 1.86%. That makes annual payments of roughly $140,000 each year back to the grantor of the trust. And the growth above that 1.86% interest rate would be shifted outside of the estate. And in this scenario, we were able to shift $41 million outside of the estate. And that's just assuming a 7% growth per year and $1.8 million of income earned each year by the company. So you can see this is a very valuable tool, provides great results, and is very easy to structure and implement and explain to your clients. There's 3 different alternatives to really do this. We talked about the skin, we talked about the installment sell. There's also the private annuity. We have some information here on the private annuity. It's a little more complicated to explain. There's a couple of more tests that would apply, and we can provide you with more detail on those if you would like. You can also do a traditional GRAT. Alan briefly mentioned on the GRAT with the SCRAT and the skin transaction. But basically, the GRAT says something's worth $1 million. I'm going to provide you with annuity payments back equal to those $1 million according to these IRS tables. Those tables use that extremely low interest rate. So again, the growth above that interest rate is shifted outside of the estate. The nice thing about the GRAT is you can adjust the annuity payments back. So if the IRS says, well, that really wasn't $1 million, that was $2 million. Well, that's okay. I still didn't make a gift because now my annuity payments back to me are going to take into account that I'm owed $2 million instead of $1 million. So the GRAT is a nice tool to use for adjustments if you're worried about valuations. But there's some comparisons in here that you can look through and figure out which one might work best for your client.
Now, a lot of clients have significant losses in 529 plans now. You just put $100,000 in a 529 plan, it's worth $85,000. Assuming that you're using no load, low cost 529 plans, do another $100,000 529 plan for your kid. That way, the first one, the next $15,000 of growth is tax-free. You'll cash that one in when it goes from $85,000 to $100,000, and the one that you put $100 in, at that time, will have $120 approximately. That's a much better tax result. We've got the numbers here for you, but and we have other information about 529 plans. You want to fund not only for college, but also up to $10,000 of tuition for kindergarten through age 12, and 529 plans are protected from creditors in Florida. So that's a good business reason to be putting more money into 529 plans. By the way, if you've watched this recording and you would like to have the information we've talked about and other materials pertinent to this planning, please just email me or email Brandon. You've got our email addresses here. Mine is agassman@gassmanpa.com. Okay, that's all we had for today. We're going to continue to be writing and lecturing on this topic. If you have any groups that would like to have a customized webinar on this, please just let us know. We want to try to help get the word out. We want to save some businesses. We want to save some taxes. And you know what? We might even save some lives doing this. Please feel free to share this webinar and these materials in any way you want to get the word out. We are people helping other people. That's what it's all about. As Steve Weinberg always says, we hope this helps you to help others. I want to close this webinar with a story. I was speaking very recently at the University of Florida LLM and Tax program about how to handle bad news, how to handle challenging situations, how to take into account that situations like this that we're in may yield fantastic results for clients who innovate, for people who start their own businesses because they don't have a job anymore, for the medical sciences that are going to be developed to help with this virus. So we're going to play that video for you now, and thanks again for attending.
There's a story that gets told over and over and over again, and it has to do with horses. And I know you have a couple of horse people here, so that's neat. You guys should definitely do a horse farm experience before you graduate. So, a dirt poor farmer in Europe in the 1600s decides that he's going to borrow all the money he can from everyone he knows and get a stallion. And that stallion is going to be bred, and he's going to make money from the stallion, and he mortgages his home, mortgages his property, borrows on everything, and he gets the stallion. And everyone from the village comes to him and says, oh my gosh, this is so nice. You got a great deal on that stallion. I think you're going to do great here. You're going to be able to pay us all back. We're going to be all happy. And he says, you know, you can't tell with life, good thing, bad thing, who knows? Good thing, bad thing, who knows? Well, he wakes up the next morning, the stallion is gone. It broke the fence, and he no longer has a stallion. He owes all the people all this money. And he said, and the people come to him and go, oh my gosh, you're washed out. You owe us all this money. We're going to have to sell your farm. He says, hey, good thing, bad thing, who knows? I'm not putting a label on it. Well, the stallion comes back, followed by 12 mares. He wakes up. There is a stallion and 12 mares. He fixes the fence. He reinforces it. The village comes up. Oh my gosh, you now have a stallion and 12 mares. Pay us back. You're happy. You're the wealthiest guy in the village now. Good thing, bad thing, who knows? What happens next? His son is breaking the stallion, is breaking one of the mares in. The mare throws him, breaks his leg. The son now has a game leg. He'll never walk correctly again. Back then, you didn't have knee surgery. They just fused it, if you were lucky. Villagers come and say, oh my gosh, we feel so bad for you. Your son can't help you in the farm anymore. Nobody's going to marry him because of the game leg. We just feel terrible. And he says, what does he say? Good thing, bad thing, who knows? Well, what happens next? The Tsar declares war. The soldiers come to get every young man in the village. They don't take the son. Everyone from the village comes up to him and says, we are crying, we're so unhappy, we've lost our sons, they're probably never coming back from the war. You got to save your son. And he said, good thing, bad thing. Who knows? So let's look at this. When does the pain from the bad news come? Does it come with the bad news, or does it come because you put a label on it? Every time something goes wrong, your garage door didn't open like it was supposed to open. Your car is making funny noises. Your friend forgot to meet you for lunch. Are you going to let those types of things get you angry and ruin your life? Or are you going to take the bigger view that life itself is the opportunity to develop as a person and to face consequences that we cannot predict or control? And that's where, in the conference room with the clients and with the other relationships, we can say, well, I'm sorry that what happened, that you're losing the $1 million because your son-in-law drove the car. But I'm glad you're not losing the $10 million, because now you're going to give him the car, get your name off it, and have $20 million of umbrella liability insurance, not 10. Aren't you glad that the universe gave you that lesson? Let's move on with the situation.